Moving on then to the next topic within the English legal system, the doctrine of judicial precedent. Very technical topic, and we're looking at how judges go about deciding cases in the courts. A favourite of your examiner. It is fundamental to the English legal system. So, what are we talking about? The doctrine of judicial precedent. We can describe it as the system adopted by the judges of following previous precedents. So, when a judge is deciding a case today, he looks to the past to see whether a judge has decided a similar case earlier. And he will then be guided by that earlier case. It's a normal human reaction, isn't it? If you've got a problem, see if somebody's already solved it. No point in reinventing the wheel every day of the week. Well, that's the idea, but it's a little bit more precise than that. Some precedents are binding, whereas others are merely persuasive. Binding. That means that the judge in the later case must follow that earlier precedent. He is bound to follow it. So it's one that must be followed by the judge in the later case. A precedent that is persuasive. A judge is not bound to follow it, but he may be persuaded to. So we describe a persuasive precedent as one which may be followed by a judge in a later case. Clearly then, it's important that we should be able to know which precedents are binding and which ones are merely persuasive. In fact, there are three factors that we have to take into account to decide whether a precedent is binding or whether it's persuasive. We've got to look at the hierarchy of the courts. We've got to look at something or other called ratio decidendi and obiter dicta, and then we've got to look at the facts of the cases. First things first, let's start off with the hierarchy of the courts. In general, precedents of the higher courts bind the lower ones, but not the other way around. And that is why when we were doing the courts earlier, I wanted you to have a picture, a diagram in your mind showing the hierarchy. And if we're thinking of the lower courts, that's the county courts and the High Court. Next one up, can you remember? Court of Appeal. And the top of the trees, the highest court in the land, is the House of Lords. So precedents of the House of Lords bind the other three because they're lower. Precedents of the Court of Appeal do not bind the House of Lords, but they do bind the High Court and the County Court. Notice, please, the High Court and the County Court sitting as first instance court do not create binding precedents because there is no lower court. A common error of students, by the way, is to say that precedents of the High Court bind the County Court. No. When they're sitting as a first instance court, they are on the same level. It's easy to make the error because you think the word high means it must be higher than the County Court, but not for this purpose. Well, we've done the extent to which the courts bind each other, but what about, do they bind themselves? So, is the House of Lords, for example, bound to follow its own previous precedents? Well, the simple way of remembering this is that it's actually only the Court of Appeal which might be bound by its own previous precedents. Well, we've been looking at courts within the country. We've now got to go abroad. The European Court of Justice, the Court of the European Community. All English courts are bound by rulings of the European Court of Justice. In fact, all courts within the European Community are bound by the European Court of Justice. So if we wanted to put the ECJ into our diagram, we'd put it right at the very top, wouldn't we? Now looking at the European Court of Human Rights. Its precedents are not binding on English courts, But as we shall see when we do human rights, they are strongly persuasive. Finally, other foreign courts. They're not binding, but particularly where there's similarities in the law, they can be persuasive. For example, New Zealand, Hong Kong, India, a lot of these countries have, at least in certain respects, a lot of similar law. So the courts in England will look to those foreign courts to be persuaded by their precedents, but not bound by their precedents. So that's the first factor, the hierarchy of the courts. Let's now go on to ratio decidendi and obiter dicta. Both of them are Latin phrases, and both of them describe something which was said by a judge in his judgment following on at the end of the case. Now, what I want to do is to describe the components of a judge's judgment, and then we'll drill down to ratio decidendi and obiter dicta. Well, when a judge is giving his judgment, and if we're thinking of, say, a House of Lords judgment, senior judges, it's not going to be a short thing, easily 1,000 pages, sometimes more. Well, the starting point is an introduction. The judge will say something like, and the claimant is Mrs. Brown, and she alleges that she bought a washing machine from White Stores Limited. She further alleges the first time she turned it on, it blew up, and as a result her house burned down, and she's now claiming damages of £5 million. She initially sued at first instance in, well, bit of revision for you. Big sums of money, isn't it? So it's going to be the High Court, not the County Court. Which division? Well, it's going to be a breach of contract claim. I'll help you with that. So it's going to be the Queen's Bench division. So he'll say she initially sued in the Queen's Bench. So the judge will say she initially sued in the Queen's Bench division of the High Court of Justice, where she lost. She then appealed to the Court of Appeal, and she now appeals to our House. So it's by way of an introduction, saying the parties, the fundamental facts, and where the case has been before, if anywhere. The next segment of his judgment is where the judge sets out the facts of the case, the evidence. It's where he will say such things like, I am convinced that she did buy the washing machine from White Stores Limited because she produced a receipt and evidence to say so. I am convinced the reason the washing machine blew up was because it had a manufacturing defect, not because she tampered with it. I was impressed by the expert evidence of Professor so-and-so. So far as court time is concerned, the facts of the case will have taken a long time, because it's where the witnesses will be cross-examined by their barristers, and so it's a lengthy proceeding. As far as the judgment is concerned, it's a relatively short section of the judgment. On to the third segment of his judgment, which is by far the biggest segment. It's where the judge states all sorts of rules of law, of varying degrees of relevance to the facts, as he found them. Then he takes those rules, which are directly relevant to the facts, applies them to the facts, and then actually decides who wins and who loses. The next step is for him to decide the remedies, so calculation of the damages, for example. And finally, to decide the issue of costs, in other words, who pays for the court proceedings. You might know as a rule of thumb who does pay. And you're right if you said it's the loser who pays. So notice if you lose a law case, it's a triple whammy. Not only do you pay damages, your own costs, but also the winner's costs. Not a good idea to lose a law case, of course. Well, going back to what we really wanted, we're looking at that big segment where the judge stated all sorts of rules of law. Some of those rules of law will be what we call ratio decidendi, others will be obiter dicta. So both of them refer to rules of law that the judge stated in his judgment. Sorting them out. Ratio decidendi, it literally translates as the legal reason for the decision. Ratio, rationale, reason. Decidendi, decision. But what we really mean, it's those rules of law stated by the judge that actually led him to decide the case in the way he did. So it's the legal reason for the decision, the rules of law. And it's that, the ratio decidendi, which is capable of binding judges in the future. If we now look at obiter dicta, literally the words obiter dicta mean other things that were said. Obiter is other and dicta was said. But what we're referring to is other rules of law that the judge stated in his judgment, but which were not the reasons for the decision. Now, we are, of course, at the beginning part of your syllabus, and this is all theory. You will get lots and lots of examples, both of ratio decidendi and of obiter dicta, as we go through your course. Just to give you, though, a simple idea of obiter dicta at this stage. Let's say the judge says, and if the facts were different, then this, I think, would be the legal position. And he sets out the rules of law that he thinks that would be. That's typical obiter dicta, because he's saying, if the facts were different, this is my opinion on the law. Now, some of you may be thinking to yourself, well, what's the value of obiter dicta? Since, as you can see in the heading, it's not binding. But even though it's not binding, it may be persuasive. And when obiter dicta is given by a senior judge, it's not likely disregarded. It's a good prediction for how the law might develop in the future. So although, say, a little county court judge is not bound to follow obiter dicta of the House of Lords, he's of course likely to be persuaded to do so. So that's those Latin phrases, ratio decidendi and obiter dicta. On then to the third factor, the material facts of the cases. Because it's only where the material facts are the same that the earlier precedent is binding. If the material facts in the two cases are merely similar, then the earlier precedent is not binding, although it may well be persuasive. And it's this that leads to endless fine-line distinctions and hair-splitting. Because let's imagine that we've got a little county court judge faced with ratio decidendi of the House of Lords. If the material facts are the same, then he must abide by the House of Lords ratio. But maybe that House of Lords ratio arose in a case over 100 years ago. He may think it's inappropriate today, and he doesn't want to follow it. Well, if the material facts are the same, he must follow it. So what he might do to avoid following it, he'll say, and this is a material fact, and it's different. And so I'm not bound by that earlier House of Lords ratio decidendi. And anybody looking on couldn't really have seen much difference in the facts at all. It leads, as I say, to endless hair-splitting and fine-line distinctions, and therefore complexity within the law. You're beginning to understand, actually, that our study of law that we'll be going through in this course is looking at facts of cases, and say, well, if the facts are different, then the law is different. And I can tell you, At the end of your course, you will have wished the judges had never invented this doctrine of judicial precedent. It makes life complicated. Well, you might have a part A to a question. Explain what is meant by the doctrine of judicial precedent, which is what we've been doing. But a part B to that very same question might well be, what are the advantages and the disadvantages? The examiner commonly says, discuss the relative advantages and disadvantages. And I want you just to take a moment to read the advantages and disadvantages, to think what it means. Now, you'll notice that each advantage has its corresponding disadvantage. I mean, if we're thinking, for example, of number 2, the advantage of flexibility the law can develop to meet the needs of a changing society. But disadvantage, rigidity, loss of development. Because, of course, if there's in existence, as we said earlier, a House of Lords precedent, and the same facts arise, same material facts, then the only court that can change that precedent is the House of Lords. So the case has to go all the way up through to the House of Lords to get it changed. So there is the counterpart for each. I am quite often asked for a bit of explanation of the third disadvantage. Patchwork nature means that case law is reactive rather than proactive. In that, it's only when some facts have arisen does the case law then get developed. If there's no case on a point, we don't know what the legal result is. Case law reacts to facts rather than predicts for the future. We'll get this when we get our live sessions at a later stage. You might ask me, well, when we're discussing a case, you might ask me, well, what would be the position if the facts were different? And sometimes I'll say, definitely that, because I know there's ratio decidendi telling us so. Another time I might say, well, it's likely to be this, because I know there's obiter dicta giving us a good prediction. Other times I shall say, not a clue. There's no ratio decidendi, there's no obiter dicta, those facts have never arisen. We don't know the answer. You just have to accept. It's patchy. There's gaps where we don't know the answers. So that then completes our study of that very important subtopic, the doctrine of judicial precedent.